In this video, we are basically going to be looking at the law governing family land. And then, of course, we'll also define what is family land, because without defining what family land is, then you'll find it very hard to appreciate the law governing family land. Then also we'll proceed to look at the restrictions on transfer of family land. And then finally, we'll look at the security of occupancy on family land. Hello there, my name is Mutiaba Conrad. I am a lawyer and a private law tutor, and before we start on our class, I encourage you to ensure that you have subscribed to my channel. Also turn on the notification so that every time I release videos and classes on various legal matters, this is always brought to your attention. And then also finally, students interested in private law tutorial sessions, please feel free to reach out to us. Our numbers are down in the description box. We can always help you, mentor you, and guide you into various legal subjects. So let's jump right into the subject of our day today, and that is basically the law on family land. And as I promised earlier, we're going to first understand what is family law, okay? What is family land according to the law. And this is really very important. And this subject is very thorny, because always issues pertaining to family land always arise in various families, and this is a very common scenario in real life and in the lives of citizens of this world. So let's first understand what is family land. What is the legal definition? Now, the legal definition of family land is a little bit wider than what an ordinary man or woman may actually comprehend or take to be the ordinary meaning of family land. Now, when you look under the Land Act, it clearly defines what family land is. And when you look under Section 38A, okay, subsection 4 of the Land Act, it actually goes on to define family land to mean land on which the ordinary residents, and these words are very, very important in this definition, okay? Land on which the ordinary residence, please mark that word, ordinary residence, is situated. So that can amount to family land. But then also secondly, land from which the family derives sustenance. Please note the word family derives sustenance. This is also very important. Or land that freely and voluntarily is agreed to be treated as family land. Okay? Or treated as family land according to culture, religion, or tradition of the family. So from the definition under Section 38A, okay, subsection 4, you will actually quickly realize that the definition of family land is actually wider. Okay, one, it includes land on which the parties ordinarily reside, okay, or where their ordinary residence is situated. Number two, it also includes land from which the family derives sustenance. It can also include land that the family freely and voluntarily agrees to be treated as family land. Then number four, it can also include land, okay, that the family uses for purposes of religion or culture or tradition, okay, that they treat as such. So you realize that the concept or the definition of family land under the law is a bit wider, and it encompasses a number of aspects. So if any of those any land that falls under any of those elements that I have defined, then the same would amount to family land. Now, you remember in that definition, I told you to note certain terms, such as ordinary residence. So what does it mean when we say land on which the ordinary residence, okay, of spouses is situated? So what does the term ordinary residence mean? This is very important. And Section 38A, subsection 4 of the Land Act has actually defined what is the ordinary residence. And this is a place one resides with some degree of continuity and intends to make it his or her home indefinitely. That is what we mean when we say land on which the ordinary residence of a spouse or spouses is situated. Very important to note. Then you also remember, I told you to note, okay, the term land from which the family derives sustenance. Okay? Derives sustenance is very important. And Section 38A of the Land Act has gone on to define what that term means. And basically, this is land from which a family derives sustenance, and this includes land the family farms, if your family is farming a certain piece of land providing livelihood of the family, land freely and voluntarily agreed to be treated as a source of income by the family. That will mean that such land is one from which the family derives sustenance. So very important. So land on which the family is farming, or land that the family has agreed, okay, voluntarily to be treated as a source of income, or where the family is actually getting its livelihood. This can be in terms of agriculture, crops, maybe animals, okay, and maybe they are selling maybe such animals for purposes of sustenance of the family. So the same will be taken to be land from which a family derives sustenance. Okay, now having understood in material detail what family land is, now we are going to proceed to look at the restrictions on transfer of family land. Now, because family land is very important, okay, for the sustenance, for the livelihood, for the existence of the smallest unit of society, which is the family, we therefore treat it with restrictions if you want to transfer it. And here, when we talk of transfer, we mean things like selling, mortgaging, all that type of transactions on the land. There are certain restrictions on the transfer of family land. So we are going now to proceed to look at some of these restrictions on the transfer of family land, because now we have already understood comprehensively what family land is. So now let's look at the restrictions, because it's not true that you can simply deal in family land as and when you wish freely. No, family land is not ordinary. There are certain legal restrictions under the law, and we are very strict on these legal restrictions. And let's now look at them in material detail. I invite you to look at Section 39 of the Land Act. It's very comprehensive on those restrictions on transfer of family land, okay? And we are going to internalize that section, and we appreciate it in material detail. Now, when you read under Section 39, it provides that no person shall sell, exchange, transfer, pledge, mortgage, or even lease any family land. You're not even allowed to enter into any contract to sell it, to exchange it, to transfer it to another person, to pledge it, to mortgage it, or lease it, or to give away any family land inter vivos, or enter into any other transaction in respect of family land, except, please note, this is very important, except with the prior consent of his or her spouse. Now, the important meaning of this section is that you cannot transact in family land unless there is consent from your spouse. So if you're married, okay, you're a married man, a married woman, you can't proceed to transact in family land in any of the ways that I have stated unless you have gotten that prior consent from your spouse. So if you're a married man and you want to sell or to even mortgage your matrimonial home or in a family land, you can't do that unless your wife or the reverse has given you consent, okay? And this consent has to be given by the other party, okay, to this other party that now intends to sell the land. Now, let's proceed. Under that same law, it also provides, okay, that subsection 1 of this section shall not apply to any transfer of land by the mortgagee in exercise of powers under the mortgage. Now, the law also says that whereas there is a restriction, okay, on transfer of land, but that shall not stop a mortgagee, okay, and the mortgagee here, this is a bank or a money lender, okay, to transfer land by virtue of the powers that they have under the law. So assuming that you had maybe taken a loan and you have been violating the terms of the loan and you have failed to pay, the mortgagee or the moneylender is allowed to deal in such family land. They are allowed to go on, for example, and sell it. Okay, that is the exception that is provided for under the law. Then also important to note is that where any transaction is entered into by a purchaser in good faith and for value without notice. Please note these words. The word is purchaser, okay, and we'll come back to that term later. And the other important term is without notice. So where any transaction is entered into by a purchaser in good faith. Now here we're talking about a purchaser of family land. So if they go on to purchase land in good faith and for value without notice of this section which we have read, and it has not been complied with, okay, here we are talking about the aspect of notice. Remember, we talked about the aspect of prior consent. We talked about the aspect of prior consent. So in case someone goes on to purchase land in good faith and without notice, then such a transaction would be void. But that purchaser, okay, will have a right to claim from any person with whom he or she entered into a transaction. So in summary, the position of the law is that transactions entered into as pertaining the transfer of family land without the consent of one of the spouse is void. And the person who has purchased such land in good faith and for value without notice, they didn't know that actually this was family land, and they purchased it in good faith, they'll be entitled to claim, okay, for their money if, for example, the money had already been passed on to one of the spouses. And such a transaction will be void, meaning that it is illegal, it is not acceptable, it is invalid to deal in family land if you do not have the consent of one of the spouses. Now, also under the law, consent shall not be unreasonably withheld. Remember, we already looked at consent, okay, and the requirement of consent. And we are saying that one of the spouses is not supposed to withhold this consent unreasonably. There should be grounds, tangible, okay, reasonable and strong grounds upon which such consent is being withheld. And in situations where one of the spouse refuses the other or refuses to give them consent to deal or to transfer, such as through sale or mortgage, this family land, there is a remedy. There are remedies given under the law. There are solutions. And one of the solutions is that if the consent has been unreasonably withheld by the other party, one of the remedies you have is that you can actually, okay, appeal or apply to the District Land Tribunal. And the District Land Tribunal has powers to vary or change the refusal to grant consent to the other party. And of course, it will have to hear the reasons. And if the reasons are grounded, if the reasons are strong, then such refusal to grant consent shall be upheld. And if the reasons are weak, then definitely such refusal shall be overturned by the District Land Tribunal. And the law gives it power under Section 39, subsection 6 of the Land Act. But then also the law actually also gives a remedy, okay, to a party upon whom, okay, a party, if one of the spouses goes on to transact in family land, okay, maybe without getting the consent of the other spouse, one of the remedies that the other spouse has where the consent has not been sought is to actually lodge a caveat, okay. So in case a man, let's say for purposes of example, a man goes on to deal in family land by way of maybe mortgaging it or selling it, this spouse can actually proceed to lodge a caveat on the land title to ensure that such a transaction does not go on. That is very important under the law. Then you also remember, ladies and gentlemen, we talked about that where a transaction is entered into by a purchaser in good faith and for value without notice. And I told you to note down the term without notice. Now, without notice, here what we meant is that that notice can actually either be actual or constructive, okay? That's also very important to note under section 39, subsection 9. Now, having looked at the Land Act in material detail, okay, as per the restrictions that the law provides, it's also important to note that these restrictions are not just simply only under the Land Act, but they are also actually under the Mortgage Act. So I encourage you to also look at the Mortgage Act because it provides some of these restrictions. And we are going to look at them a little bit more in detail under section 5 and 6 of the Mortgage Act. It's important to note that there are principles, there are other restrictions when you're mortgaging a matrimonial home, for example, under section 5. Okay, there are certain restrictions, there are certain duties that the mortgagee has, and that is the bank or the money lender, okay, the party issuing out the money. Okay, there are certain restrictions that are provided for. But let's start from section 5 of the Mortgage Act so that you're able to appreciate these restrictions. Now, under section 5, subsection 1, it provides that a mortgage of a matrimonial home, okay, including a mortgage on customary land of a matrimonial home, is valid if, it's only valid if, number one, any document or form used in applying for the mortgage is signed, okay, and assented to by the mortgager. So meaning that the person who is mortgaging a family home must sign those forms and consent, okay, to them going on to mortgage such a matrimonial home. Then also it goes on to state that any document or form used to grant the mortgage is signed by, or there is evidence that it has been assented to by the mortgager and the spouse or spouses of the mortgager living in that matrimonial home. So if they are mortgaging a matrimonial home, it's also very important for the other spouses to consent to the same. And the law goes on to say that an intending mortgagee shall take reasonable steps to ascertain whether an intending mortgager is married and whether or not the property to be mortgaged is a matrimonial home. So meaning that the bank has to ensure that actually it goes on to make sure, because you see the position of the law is very clear, that a mortgagee shall take reasonable steps to ascertain whether an intending mortgager is married and whether or not the property to be mortgaged is a matrimonial home. So the bank has to ensure, it has to do due diligence to ensure whether what is being mortgaged is a matrimonial home or not, and what type of property is being mortgaged. And then also, the law also provides that a mortgagor shall make full disclosure to the intending mortgagee as to his or her matrimonial status. So the spouse also has a duty, or the person who is going to this money lending institution, to ensure that you disclose the facts as to whether, one, you're married, what is your status, and whether the property you're giving to the bank is actually one which is a matrimonial home. So you also have that duty. But let's proceed now to look at section 6, because it is authoritative. And section 6 provides for the requirement of consent to mortgage a matrimonial home. So there has to always be consent when we are dealing in the mortgage of a matrimonial home. And section 6 provides for the duty of a mortgagee or a bank. And one of the duties they have is as follows: that a mortgagee shall satisfy himself or herself that the consent of a spouse, referred to in subsection 5, which we just looked at, is an informed and genuine consent. So when the bank is proceeding to give a mortgage, it has to ensure, and these are some of the restrictions which we are talking about, it has to ensure that there is consent, and that consent has to be informed and genuine. And the law has defined, okay, under section 6, subsection 2, what is an independent, who is an independent person, because this consent has to be got from an independent person, and we'll look at that. Now, under section 6, the law goes on to state that the mortgagee, it goes on to state that the duty is deemed to have been complied with if, meaning that now the mortgagee has a duty to ensure that, one, he explains to the spouse, that the mortgage has been explained to the spouse or spouses of an applicant for the loan for a mortgage in the presence of an independent person. So the bank has to ensure that they have explained, okay, to the spouse in the presence of an independent person. And as I said earlier, under subsection 2, an independent person has actually been defined. And this means any office of government, a justice of peace, an advocate, a notary public, a bank manager, etc. So there has to be that independent person to try and explain that. But also the law provides that the mortgagee has, okay, in writing to advise the applicant for a mortgage that he or she should ensure that his or her spouse or spouses receive independent advice. So the spouses also have to get that independent advice, and the mortgagee has to inform in writing, okay, the mortgagor to ensure that the spouses get that independence advice on the terms and conditions of the mortgage. And then finally, also the spouse or spouses, as the case may be, provide a signed and witnessed document to the effect that they have received independent advice on the mortgage. So the bank also has a duty to ensure that these parties sign a document showing that they have actually proceeded to get that independent advice. So these are some of the restrictions, ladies and gentlemen, on this matrimonial home or matrimonial property that always has to be complied with. And these restrictions are really very strict, okay, because we look at them we always consider them. And in case these are not complied with, this can always jeopardize. And of course, such a transaction would definitely be an illegal transaction. So let's now proceed, ladies and gentlemen, to look at the security of occupancy on family land. Now, on family land, again, the security of occupancy is provided for under the law. I encourage you to look at Section 38A of the Land Act. It provides for security of occupancy to married spouses on family land. And of course, the law requires that every spouse shall enjoy security of occupancy on family land. That is one. But also, secondly, the security of occupancy means a right to have access to and also to live on such family land. And then also, lastly, the spouse has a right to use that family land and also to give or to withhold his or her consent to any of the transactions pertaining to family land. So basically, that is the law that pertains to security of occupancy on family land. So basically, ladies and gentlemen, that is what we had to look at today in our class. And basically, to do a recap on the same, we have looked at the law on family land. We have defined what family land is. We also proceeded to look at the restrictions on the transfer of family land, and we looked at also the restrictions under the mortgage, the laws of this land, and also we looked at security of occupancy on family land. So that was it, ladies and gentlemen, for our class. We meet in another class. If you have not yet subscribed to my channel, please ensure that you subscribe to the channel. Also turn on the notification so that every time videos are released, this is brought to your attention. Also like and share this video with your colleagues so that they are also able to benefit from this knowledge. And also students interested in private law tutorial sessions, please feel free to reach out to us. We will be able to help you, and our numbers are down in the description box. Thank you. We meet in another class. Bye-bye.